Folks, breaking news in the fight for gun rights in our federal courts. As most of you know, 10 days, 2 weeks ago, Supreme Court finally agreed to consider whether or not the government can ban AR-15s. One case comes from Illinois' 7th Circuit, and one comes from Connecticut's 2nd Circuit. Both cases will be heard in oral arguments probably in October. We should have a verdict, hopefully, June of next year. It's a big, massive development in the fight for gun rights. But to kind of accentuate the point, in an en-banc decision last Friday, the 3rd Circuit comes out and they struck down New Jersey's ban on AR-15s and the state's 36-year-long ban on so-called high-capacity magazines. X is on fire. The left is melting down. So eat your commie heart out, all you Democrats in government in New Jersey and the rest of Blue America. So we're going to cover this case and begin with a timeline so you guys know how we got here in this situation. So 1990, we're going way back here, 1990, then Governor Florio signs a ban on AR-15s into law, as well as a ban on magazines that hold over 15 rounds of ammo. And it came way back then with a penalty of 10 years in prison for a violation and a fine of $150,000. Now, as we all know, you can commit murder, you can commit violence, sexual assaults, armed robberies, all kinds of violent crimes will get you less than 10 years in prison. But these people hate gun owners, and that's why they have this penalty. So 2018, fast forward to almost 40 years, New Jersey lowers the round count of their magazine ban from 15 down to 10. So today it's a felony to have any magazine that holds over 10 rounds of ammo. Now, when that happened in 2018, there were lawsuits filed almost immediately challenging all of this, and all of them failed. The 3rd Circuit upheld these laws as being constitutional, and for the moment, all hope was lost. But then, as you guys probably all know, June 23, 2022, the Bruen decision is handed down by Clarence Thomas and the rest of the United States Supreme Court, and this changed everything. Because before Bruen, when a gun control law was challenged in court, the court reviewed the law to see if the conduct was covered by the Second Amendment. So, for example, you want to buy an AR-15. Is buying that gun protected by the Second Amendment? If it was, the court could still ban them under a means-end scrutiny test that basically allows the court to say, yeah, you've got a right under the Second Amendment to do this, but the government has made a great public safety argument, and that trumps everything else. And it's why we lost in court for over a decade after Heller and McDonald from 2008, 2010. But Bruen changed everything. The standard today is, number one, is the conduct in question covered by the Second Amendment? And then if yes, can the government show historical examples of similar gun control laws on the books when the 2A was ratified back in the late 1700s? If there are no similar examples, the gun control law on the books today is deemed unconstitutional. That standard has changed everything. So going back to our timeline, we get Bruen in June of 2022, and that same week, these lawsuits from New Jersey were appealed to the Supreme Court, and new suits were filed on top of that. The Supreme Court then orders the 3rd Circuit to reconsider their previous decisions in light of Bruen. The 3rd Circuit then kicks it down to lower district court judges and says, re-review this entire thing. July of 2024, the federal district court judge upholds the state magazine ban, but strikes down New Jersey's ban on the Colt AR-15, just the Colt AR-15. The judge in that case says the state produced historical examples that justified the continuation of their magazine ban. And wait till you hear the argument in a few minutes. It was a chicken shit ruling from a chicken shit judge. And both sides, New Jersey and gun owners who filed the suits, appealed all of this to the 3rd Circuit. July of last year, July of 25, a 3-judge panel hears oral arguments, and finally October of 25, the entire court, all the justices on the circuit, heard oral arguments. That was July of last year. Fast forward 1 year, July 17 of this year, 2026, the 3rd Circuit rules that the entire assault weapons ban, their words, not mine, not just Colt AR-15s, is unconstitutional. And they also find the state's magazine ban to be unconstitutional as well, a true twofer in the fight for gun rights. So There is an irony here, right? Because this is the same Third Circuit that previously upheld both of these bans, but Bruen, again, changed the standard by which these judges are allowed to decide Second Amendment cases. Got some great quotes here from the court. The court said, for several years, our court interpreted the Heller decision from 2008 to require means-end scrutiny as part of any Second Amendment analysis. The Court of Appeals has coalesced around the two-step framework for analyzing Second Amendment challenges that combines history with means-end scrutiny. As it turns out, we all missed the mark. I'm going to keep going, but here's the deal. This wasn't written by Clarence Thomas. It was written by a circuit court judge. And this judge was not some Trump appointee from this administration or the previous one. It's written by a black Democrat female judge appointed by Joseph Biden. Will miracles never cease? She goes on to say, instead, courts must approach Second Amendment cases under a different two-step framework. First, we have to ask whether or not the Second Amendment's plain text covers the conduct in question. If the answer is yes, the Constitution presumptively protects that conduct, and the government cannot justify its regulation by simply positing that it promotes important public safety interests. Instead, the second step applies. The government must demonstrate the regulation is consistent with the nation's historical tradition of firearms regulation. If it is not consistent with that historical tradition, it cannot stand. So right off the bat, the judges get it right. They're using a new standard. It's the Bruen standard, written by Clarence Thomas, and that, again, changes the analysis. Now, regarding the lower court's decision to allow the Colt AR-15 ban to be lawful only, the court said that was stupid, and they said right off the get-go, our decision covers all types of commonly owned semi-automatic rifles, all AR-15s in particular. Now, you should note this. They did not take up the issue of semi-automatic handguns or shotguns. They said there was not enough evidence brought forth in the lower courts either way, and so lower courts will have to reconsider that issue going forward. So this is all about AR-15s in New Jersey. So the first part of the Bruen test, are AR-15s arms, and is the attempt to own them covered by the Second Amendment? The court said yes to both. The court agreed with the goal of New Jersey when they banned these to lower crime. Now, we all know that's bullshit. These bans never lower crime. That's not why the Democrats passed these laws. But the court said that a blanket ban on firearms like this is unconstitutional. The court cited both Heller and McDonald's common use argument. If a firearm or accessory is in common use, the government has almost no chance to restrict it. Now, the opposite of common use is dangerous and unusual, a standard laid out in the Heller Supreme Court case in 2008. So you have common use firearms and you have dangerous, unusual firearms. What does that mean? Well, machine guns, SBRs, SBSs, grenades, etc. Now, I want to be clear on this. We do not agree with that standard. Citizens should be able to own machine guns, short-barreled rifles, short-barreled shotguns, all the rest of it. The reason is pretty clear. It's the dang Second Amendment. But that's not all. If we grant the argument of dangerous and unusual firearms, that comes at a future cost. See, when the Democrats ban AR-15s, there's obviously going to be less of them in a state. So subjecting the limits of our freedom to a numerical decision is just stupid. It's dangerous. Now, we'll take the win here, to be clear, but there is a downside to using the common use versus dangerous and unusual firearms standard because, after all, to the Democrats, your Glock 9 is dangerous. Your Ruger 1022 is dangerous, and they're all unusual to today's Democrats. So we prefer more constitutional arguments versus numerical ones. But again, in this case, we're definitely going to take the win as gun owners. So back to the Third Circuit. They held that since there are 24 million ARs in circulation, and that was not contested by New Jersey at all, they said these are in common use and therefore protected by the Second Amendment. The second part of Bruen test then is, are there historical examples of similar restrictions on the books in the late 1700s? Now, New Jersey argued that there is an example, and they cited a law from New York City in 1784 that banned the possession of more than 28 pounds of gunpowder in a person's home. So they said that law from way back in the day is the same as having a limit on magazine capacity in AR-15s in 2026 America. The court laughed at that, and they said that's ridiculous. That law dealt with preventing fires in an urban environment. It had nothing to do with the idea of the Second Amendment, keeping and bearing arms, ammunition, or anything else. The court finished off this section by saying that AR-15s are used for a variety of lawful purposes: hunting, target shooting, self-defense, and more. We would add, of course, defense against tyranny, but we're not on the bench. And in conclusion, New Jersey's ban on commonly used firearms for lawful purposes was the same as the Heller case, which involved handguns in D.C. And so, like Heller, the court struck down New Jersey's AR-15 ban. The court's quote was, "Together, Heller and Bruen teach that bans or broad prohibition of possessing or carrying a class of weapons in common use for lawful purposes fails to find support in our nation's tradition of firearms regulation. That is so even when the regulations are passed with the intention of reducing gun violence." Again, that's a stupid, moniker. We reject all of that. But their point was the same. We're going to strike down the AR-15 ban in New Jersey. Then they jump into the idea of the magazine ban. This got really fun as well. First, again, Bruen's Part 1 test. Is this activity, buying and owning these magazines, covered by the Second Amendment? And the court said it certainly was. They gave 3 different reasons as to why. They said, first, you have to have a magazine to use the gun. Their quote was, "A magazine unquestionably facilitates the user's ability to cast or strike at somebody else." That's a quote from the Heller decision. So accordingly, magazines are part of arms in the Second Amendment. Number 2, they said the round count doesn't matter. Their quote was, "Nothing in text of the Second Amendment suggests the capacity of a magazine bears on whether or not it is a constitutionally protected item. So it cannot be that a magazine that can hold 10 rounds is an arm covered by the Second Amendment, but a mag that holds over 11 rounds is not." It's a very obvious argument they made. You can't, if you're New Jersey, you can't say 10 rounds and less, that's okay. 11 rounds and more, 10 years in prison. That's just not constitutional at all, and the court got that very correct. They also said the idea of large capacity magazines is political, not objective. And they pointed out the obvious hypocrisy. From 1990 to 2018, New Jersey said the max was 15 rounds. But then in 2018, they drop it down to 10. And the court all but mocked them for being arbitrary. Their quote was, "The text of the Second Amendment does not limit arms to the minimum equipment necessary to operate the weapon. Nowhere in Heller or Bruen's analysis did the Supreme Court suggest the availability of alternative equipment changes the definition of an arm under the Second Amendment." So their point was, sure, a 10-round mag works, but you can't use that as justification to ban mags that hold over 10 rounds of ammo. The court then jumped over to the second part of the Bruen test. Are there historical examples of similar gun control laws on the books when America ratified the Second Amendment? And here again, all New Jersey could do was restate their tired, failed argument about 28 pounds of gunpowder being the limit in New York City in 1784. And again, the court laughed at that and said, no, that's in the context of stopping fires in a city, not an argument for or against the right to keep and bear arms. So when it's all said and done, Jersey lost both their AR-15 ban and their ban on magazines over 10 rounds of ammo. So a fantastic win for gun owners. And again, written by a Biden-appointed liberal woman judge in the Third Circuit. So, of course, it's never just this easy. From here, the case was remanded back down to the lower courts, who have to review this case and issue new decisions that are consistent with the Third Circuit and the Supreme Court's Bruen decision. But either way you cut this, these are wildly exciting times for gun owners in blue states have been waiting in some cases for decades to have these laws challenged. Illinois, Washington State, their bans took effect just in 2023. But in New York, their ban's been in effect since 2013. And for California, it's been since 1989 that this law first took effect. So again, like I said, relief could finally be in sight. The court's going to take up not one, but two different challenges to the assault weapons ban case in their fall term. And this now has much more urgency because we now have conflicting circuit courts. Because, again, the 1st, 2nd, 4th, 7th, and 9th, and D.C. circuit courts have all upheld the AR-15 ban as being constitutional. The 3rd Circuit is the first circuit to officially disagree. That's why this is such a big deal. When you have conflicting circuits, SCOTUS has to get involved and say, here is how it's going to be going forward. Guys, it's all going to happen later on this fall. We'll keep you guys up to date as the entire thing barrels towards Clarence Thomas's desk later on this year.